Hello everyone, this is MAHEK, Legal Internet LEXIS and Company. Welcome back to our channel. This video is in continuation with my previous video that talks about declaration or the dying declaration or the state or the relevancy of a statement of a dead person under under Indian Evidence Act. In that video, I have discussed what is the dying declaration is, how what are the categories of person the section 32 of Indian Evidence Act deals with, and then I have discussed section 32, how a statement would be considered as a dying declaration, and what are the essential elements of that section 32. In that we have numbered four basic elements of section 32. First one is the person making the statement, I have died after time. Then we have the statement would be talking about then we have that statement. Then the statement would be referred to some cause of the death. Then if not the cause of the death, then third one is any of the circumstances that resulted in the death of the person. And the last we have the person should be of a competent mind. We'll be discussing one by one each of the elements in this video. Let's start with the first one, that the person stating must have died after time. A dying declaration or statement made by a person is in critical condition would be relevant as under section 32 only if the person making the statement would have died after time. If that person, however, the critical condition is, however, there is an expression that the death might be caused, might be the end result of a situation, no matter if the person survived after later time after the treatment. For example, A had been stabbed by B, and then later the A reached the hospital, and during the treatment A narrated the whole entire story to doctor, that how B had called him, how B had grabbed the knife, how B have stabbed into him, and how he's come to the hospital, all the story. And but after the receiving treatment, he survived the injuries, he became well, and then being discharged from the hospital. But after being discharged, a period of 3 months, he died. Then his death or the statement made by him before the doctor during the treatment wouldn't be relevant if the injuries were completely healed and the cause of the death is something distinct from the statement or the injuries that he had mentioned in his statements. For being the statement as relevant, it must be in reference to one with the direct cause of the death. Direct cause of the death means that the person directly stated that A had stabbed me the knife. The knife could be found there, and A is dead. And later, by stating after this the person maybe died during the treatment, then that statement would be considered as relevant as a dying declaration under section 32. But not if the direct cause of the death, but if the person said some of the circumstances, that how A had called him, why A would have called him, what was the agony in the B against him, how B reached to the knife, and why he how he managed to get into the hospital, what are the circumstances, where the place was, what are the nearby people, how the nearby peoples were. All this, narrating any of the stories or any of these situations, things would be considered as dying declaration if soon after making the person died. And even not the soon after, time is not the essence in section 32. Even if the person died after 2 to 3 months, but the person would have died with the effect of the injury so caused, or the statement or the death must be in reference in related to the statement made by the person. The contents of the statement should not be entirely different from how the death has been caused and the reason of the death. It must be somewhere related to the death in real sense. Then we have the person should be of a competent mind. It's not the case the person was in some fits or in some mental disorder. He narrated the story while he was being dead. He must be mentally sound. It not in the pretext of it's not in the case of intoxication. He should be, or there must be he was not in his senses. He must be in senses just before the person died. This was all the constituent elements of section 32, but this section clearly means it's not matter. However, the critical condition is, even if there is no expression that the death would have result, even after making the statement, the condition of the person making the statement is irrelevant at the time of making the statement. Once the statement is made and the person died, it would be irrelevant in what condition the person was. And what are the facts? So Indian law does not accept that. Do not say that the person should be in a critical condition, that he's seeing his death just near about. It's not the case under Indian law. So that is the second part of section 32 clause 1. Further, the evidentiary value of dying declaration is just a mere relevant statement. Is not a substantive piece of evidence. For being it considered as a piece of evidence, it needs to be corroborated by some other facts and circumstances and evidences. Or solely a decision cannot be made. The decision cannot be made solely on the statement of a dying person. This was all about section 32. I hope I made my part clear. Hope you like this video. Do like and share and subscribe the channel. Thank you.